given the fact that the panel's report was riddled with legal and factual errors, and then there's another important point, which I'll add to it, in addition to other pending procedures such as investigations by the Hawks, the ANC took the view to be unconstitutional to proceed. Now I ask this court, what has the Hawks got to do with this case? What has the Reserve Bank got to do with this case? What has SARS got to do with this case? What has the Public Protector got to do with this case? Nothing. They are not. So that in and of itself is the height of irrationality. Even if one accepts the debate that we've had this morning concerning the question of whether the panel got it right on prima facie and the question of sufficiency. By the way, the ATM says the panel's report is perfect. It's inch perfect. And any suggestion that it was riddled with legal and factual difficulties is wrong. And I'll come to that. But at first instance, there are two reasons. If one of those reasons is bad, we win. That's this court's jurisprudence, Westinghouse, etc. If there is a decision maker, such as Parliament, egged on by the ANC, and one of the reasons by the ANC which eggs on Parliament, one of those reasons is bad, the decision is bad. The report was riddled with inaccuracies because of what he stated in paragraph 30 of the ANC's heads and what he stated in the President's heads. Perhaps the President's heads do it in perhaps a neater way, and that is in paragraph 52. They start with three reasons. This is the panel. Report. So this is why the President says the panel was bad. And they give three reasons. The first reason, the panel must... Don't say that by saying, oh, well, there's a good reason because the report was riddled with inaccuracies. Now we turn to why was the report riddled with inaccuracies? Well, the report was riddled with inaccuracies because of what he stated in paragraph 30 of the ANC's heads and what is stated in the President's heads. Perhaps the President's heads do it in perhaps a neater way. It's another problem with the report, the President says. And the third one is, above paragraph 58, no inquiry into bad faith. Three reasons why the report is bad. That's what the President and the ANC rely on. The ANC in paragraph 30 sort of develops it in some kind of a nuance. That is in paragraph. Let's start off with the third one. They start with three reasons. This is the panel. The report to do one thing. This is why the President is what I'm going to call in Cape Town terms a rubbish reason. Paragraphs 58 to 63 of the panel report. It's pages 86 to 87. There, the panel deals with bad faith. It explains what it understands by bad faith in detail. So when the President says to Parliament, so when the President says to this court, and the ANC says to Parliament, says the panel was bad. The panel got it wrong because it didn't. And they give three reasons. Of course it did. Look what it said. The first reason, the panel misunderstood its mandate. That's the sufficiency of evidence, the prima facie issue. But earlier, and there are The bad faith is 4 paragraphs dealing with 52, 3 and 4. Dealing with 54. Chief Justice Mufweng said in the Public Protector of South African Reserve Bank case. 63 they conclude, and they go to the dictionary definition of bad faith. Paragraph 63. We think that bad faith can be inferred from the nature and the circumstances surrounding the violation of the Constitution of the law. Constitutional law and misconduct. The next problem that the President dismisses a Director General because he wants to appoint in his place his relative. And then it explains where the President gets it wrong. He acts unlawfully, but not in bad faith. He's given advice by a lawyer, and the President makes a mistake. He brings the Pharmaceuticals Act into operation. It wasn't in bad faith. He made a mistake. He acted irrationally. Bad faith is when he wants to appoint his relative to the Director General, or he gives a criminal a pardon because the criminal paid him to do so. That's bad faith. And the question arises, we've been in democracy for 30 years. How long will we wait for a president to come to a panel and say, yes, I acted in bad faith? Never. It will never happen. Every president will come to the panel and say, I acted in good faith, I made a mistake. So the bad faith argument by the ANC, one of the 3 pillars, falls. The panel did look at bad faith and it said, we're going to look at what happened. The couch, the reporting to General Roder without going to a proper policeman, all of those things. And the panel says that's bad faith. Wrongly or rightly. But you cannot criticize the panel for not inquiring into bad faith. They did. The second, let's go going backwards. The second problem the President identifies. The President equated evidence with information. Let's look at what the rule actually says. The rule says what the panel can do to come to its decision on sufficiency of evidence. It's in 129G. 129G. 129G, paragraph 1, paragraph C. It says, in considering the matter, the panel may in its sole discretion afford any member an opportunity to place written or relevant written or recorded information before it with a specific time frame. Must provide the President immediately with copies of all information. Must provide the President with a reasonable opportunity to respond in writing, etc. 4. Must not hold an oral hearing and must limit its inquiry to the relevant written and recorded information placed before it by its members, and must in its report include any findings, including the reasons for such findings. And now what the ANC and the President do is they say, there's a heading, they say, when the panel looked at the information, it was a flawed consideration because it could only look at admitted evidence as per a court of law. Wrong. It's information that will give rise to sufficient evidence or may give rise to sufficient evidence. How can the admissibility of information from the President who may only write, they can't hold hearings, how can that ever be equated to the requirement of admissible evidence in a court of law, an affidavit or a person who swears on oral oath? You won't even have an oral hearing. That would be counter to common sense. So the ANC's and the President's criticism report on that leg also fails. So 2 out of 3 knocked out. We don't need to go to the third one, Justice Matopo, etc., on the question of the distinction between prima facie evidence and sufficient prima facie case. Not prima facie evidence, it's prima facie case, and sufficiency of evidence. The Mokokwa case raised in the debate with Justice Majid is an interesting one. And it's for this reason. In South African law, under Section 10 of the Extradition Act, 10.1 and 10.2, go and look at that. The question arises as to whether in the foreign state who sends an extradition request to South Africa, Mr. Rob, there is sufficient evidence to warrant the prosecution in that state. And what happened in Makwakwa, so sufficiency of evidence to warrant a prosecution, that's the term of art in South African law. And I'll come to a broader argument about that term of art, sufficiency of evidence. It's a 1962 piece of legislation which was amended, I think it's the early 2000s, to include that section, sufficiency of evidence. I think in 1962 it was prima facie, but I'll come to what. And what happens is section 10.2 says, when the foreign state requests extradition for determining the sufficiency of whether the foreign state has sufficient evidence to prosecute, a certificate from the foreign prosecutor suffices. What happened in that case? The foreign prosecutor in Lesotho says, we don't know, he didn't say that, is what actually happened. He issued a certificate. And the certificate said, we, the prosecutor, have prima facie evidence to prosecute the man. And the defense in South Africa said, the certificate said there were prima facie evidence, but he's got to show it's going to be sufficient evidence, a la section 10.1, and read with section 10.2. Therefore, I win my extradition, because the certificate is bad. The High Court said no. And if one reads paragraph 40 of the High Court judgment, the point is very neatly made as to why the notion that this court has been debating about this big difference between prima facie case and sufficiency of evidence is really a red herring. And it needs to be the first to say, I know the debate, I think it was with Justice Majid and Mr. Premert, touched my heart on the question of, in the criminal matter, if the trial judge gets it wrong, of course the conviction must fall. And in the case of ATM in the Supreme Court of Appeal, when Mr. Premert acted for the Speaker, I acted for the ATM, and I lost in the High Court, and I came to the SCM, I said, hey, the Speaker got the test wrong. The UDM case had given a blank slate, and the Speaker said there's a default position. You can't have a default position if you use a blank slate. And the SCI held my argument. The point I make is, I accept, as I must, that if the decision maker gets the wrong test, like the criminal court gets the wrong test, as a matter of principle, the conviction will be set aside. As a matter of principle. But what's the principle here? There's none. And let's read Makwakwa. Paragraph 40. There are varying degrees of prima facie evidence. Prima facie evidence can consist of incomplete evidence, for example. A single piece of, because remember, this is an answer to the question of the certificate from Lesotho saying they've got prima facie evidence which doesn't satisfy the South African Section 10 test of sufficiency of evidence. And this is what the High Court says, and we submit correctly so. So, what does it say? Prima facie evidence can consist of incomplete evidence. For example, a single piece of circumstantial evidence, a fingerprint, which will easily dissipate in the face of a plausible explanation. On the other hand, it may be a strong prima facie case, e.g. eyewitnesses, forensic evidence, and a confession. Prima facie evidence at its weakest is sufficient evidence to institute a prosecution. Highlighted. Prima facie evidence to warrant a prosecution in all manifestations, weak or strong, will therefore constitute sufficient evidence to warrant a prosecution. End of the story. There's no debate. I want to add to that. All over the world, in these kinds of cases, you have different tests. In the United States, it might be probable cause in some states. In Europe, there's different standards in the criminal prosecution, when you start and when you don't start. And I take Justice Colopin's point, that there's a difference in use of language, and there's the answer, Makwakwa. It's a different type of debate when the speaker tick box and when the panel tick box. So we submit, we only have to come home on one of the four. The further evidence that they're waiting for, not a good reason to strike down the report. Of the other three, all three are bad. The President and the ANC's reasons, all three are bad, but we only have to come home on one of them, on Westinghouse. So we come home. I turn to the rule, because I made the point that the rule is bad vis-a-vis EFF 2. I have to accept there's a delay problem and a potential mootness problem. I agree with Mr. Premad fully that the court, as we would submit, is obliged to consider at least the rule. The rule can never become moot. The rule's on the books today. It's a new parliament, it's got the same rule. So mootness is already as far as the rule is concerned. In principle, I suppose, in principle, but I don't concede it, in principle an argument could be made that the striking down of the resolution could be moot. But we don't concede it, but that's just an in principle argument. As far as delay is concerned, any one of the 400 members of parliament today could bring a challenge to the rule. And nobody can accuse that member of parliament of saying there's a delay. It's a rule, it's alive, it's operative. And either it's bad or it's good. It can never be suggested that this court could abdicate its responsibility to avoid looking at that rule now. It's on the books. So why do I say that the rule is bad? Well, we've had debates about what the Assembly can or can't do in order to achieve the result of an ultimate Section 89 impeachment. And I want to turn, well, before I do that, let me turn to EFF 1. EFF 1, Justice Matopo had a long debate with my learned friend on the question of the people telling the representatives what to vote or not vote, or the representative issue, separation of powers. Justice Sigurban raised it, many of the judges have raised it. The court will be minded to consider paragraph 10 of the order in EFF 1, the Nkandla judgment. And this is what this court ruled. Chief Justice Mokgeng, the resolution passed by the National Assembly, so it's a resolution passed by the National Assembly, that's what we're busy with here, absolving the President, it's a different President, it's the same thing, absolving the President from compliance with remedial action taken by the public sector, and you could take those words and put them in here, from enjoying the benefits or the disadvantages of an impeachment committee in terms of whatever section it is inconsistent with Section 42.3, 52.2a and b of the Constitution, invalid and set aside. So this court is well geared to taking on the separation of powers red herring. It's done so, it did so, as long as Mohammed, tak, grootboom. Separation of powers means this court's got to do what this court's got to do, and if there's an unlawfulness or an unconstitutional behavior by anybody, including the National Assembly, including the President, this court has a constitutional obligation to say so. So separation of powers doesn't come into the picture if the National Assembly acted unlawfully. I've already showed you that it acted unlawfully because it acted for two big reasons, one of which had three tributaries, all four are bad. On the ANC and the President's version. So we come to why I say this rule, 129I, or 129I in the context of 129 as a whole is bad. When one looks at the majority of EFF2, one has to compare it with what the minority said, because it doesn't have to just see what the majority said. As we understand it, there was a complaint about the President, former President. And there were no rules set out as to how to get to a final vote on impeachment. And what the majority said, there need to be rule specific, a rule, dealing with impeachment like Mazibuku versus Sisulu in the motion no conference context. And there wasn't such a rule, therefore you, National Assembly, go make a rule in order to comply with the Constitution, and they made a rule. But in making that rule, they had to look at what was the rule about. So I'll start off at 192. Because what 192 of EFF2 does is it tells Parliament what it can't do. And what it can't do is have a political majority stymie an impeachment committee hearing if there is prima facie evidence, sufficiency of evidence. That's what it tells Parliament to do, and that's exactly what Parliament has done in this case. It is allowed for the 129 process to be politicized by that vote after the panel reports. That's what JAFTA-JA warned against and said, you can't do that, and that's what they've done. So in 192, the rules relevant to the establishment of the committee, those are the ad hoc committees that Parliament can establish, which the minority found were okay, and now he says why they're not okay, do not determine the size of a committee, nor do they require that all parties be represented. They merely state that the resolution establishing such committee must specify the number of members to be appointed or their names, if more than one party is represented, etc. The majority party would have majority representation. Now we start. This raises the risk of an impeachment complaint not reaching the Assembly, even if the resolution establishing the committee were to stipulate that what was before the committee may not be decided by consensus. There, I underline the following sentence. A decision by members of the majority party in the ad hoc committee may prevent an impeachment process proceeding beyond the committee to shield the president who is their party leader. That's what happened here. In recognition of the point that impeachment proceedings are partisan, the acting speaker said, the initiation of such proceedings is inherently partisan. Acting speaker in that case said that. As the aim from the outset is the removal of the president, who will almost always be the leader of the party represented. And then 193 segue into the point that I'm going to finalize my presentation on. In the context of section 102 of the Constitution, this fought in Mazibuko, I've indicated the reference, the proposition that the tabling of motions of no confidence envisaged in that section with only the support of a majority was consistent. This court said that was rejected. That proposition was rejected. And I'm asking this court to reject what happened here in the same way. What 129I does exactly what was rejected in Mazibuko and in EFF 2. It's a repeat. Repeat. That's what this is. A majority decision, this court said in Mazibuko, a majority decision of the program committee on the scheduling of a motion no confidence could frustrate the vindication of the right envisaged in 102. This would be so because, again, as in the case of consensus requirements, it would be within the discretion and generosity of the majority within the program committee where the motion no confidence the president would ever see the light of day. And now an important sentence, which the rule gives absolute violence to. By parity of reasoning, the committee system is not suitable here too. So what the court says is this, what this court says is we have a committee system where the majority determine whether the thing should go forward. Not a good idea, it's unconstitutional because the majority will stop the inquiry but you won't see the light of day. We have it worse here because here's a panel report sent to the National Assembly, which could be another term for an ad hoc committee, because an ad hoc committee is just the embodiment of the National Assembly as a whole. So what one has is Parliament may strike down the report. Broad, wide discretion makes no difference. This rule is bad because it falls foul of what this court determined needs to be done when it comes to a Section 89 rule. I've used 7 minutes 30 seconds, and I'm happy to waive the extra 2.5 minutes, as it pleases you, Chief Justice.
Thank you, Mr. Coates.
Mr. Katz, just briefly, you referred to the committee system as being bad, imposing, as it were, the tyranny of the majority over the minority.
So excuse me, sir, I'm
imposing the tyranny of the majority over the minority. Now, it's been said that, democracy is probably the worst form of government, but until we find a better system, it's the best we have. Under those circumstances, are you suggesting that the manner in which the National Assembly conducts its business and votes, and it engages the Constitution, but it's also an intensely political process, that this court should, in your invitation to set aside the rules, reach the conclusion that because rules, which on the face of them may be intended for people acting in good faith, could however be abused, and purely on that basis reach the conclusion that the rule is inconsistent with the Constitution. Would that not be, one, placing the court in a position that I don't imagine the drafters of the Constitution could have ever contemplated, is exercising this sort of superpower that even the Constitution doesn't contemplate? And doesn't that undermine, as it were, the workings of the National Assembly? Because in truth and reality, the National Assembly will take decisions that people may be unhappy with, and there might be an abuse of the system in place. But to fine-tune that, to take away, as it were, the exercise of the democratic will under circumstances where it may not be constitutional, could have a chilling effect.
Just not in this case, but I missed the sentence, because you also you put a particular sentence to me, which was a very important one. Could you just repeat it? I just wanted to be clear.
I put many important, all my sentences were important, Mr. Katz. But what do you recall of it that was so important? Then I can try and only know it.
Let me try and answer all the important questions in one answer.
Okay, thank you.
I have to accept, not have to, I don't have to accept it, we accept that as a matter of principle, ultimately, it's for the National Assembly to determine whether there should be impeachment or not. Ultimately. And when it does so, it must do so rationally, lawfully. But ultimately it's their decision. If they are paid, if every one of those members are paid to vote in a particular way, yes or no, that's not a rational, not a lawful decision. And I don't believe that this court could have any qualm with that. So the real question is this: did the National Assembly, and I want to come to, we're not even at impeachment. We're not even at the impeachment committee yet. We're at a far stage. We're not even getting to what the EFF2 said was frustrate and even debate about the issue. We haven't had a debate about impeachment yet. That's the 89 committee. So now what the majority have said is, we're stopping even a debate on impeachment, even though there are prima facie sufficient evidence, bad faith, all of those things in this case. That effectively. Now, can it be rational for them to do so? And we said, but obviously not. How can they strike down a report, if I use that language, when the basis for them doing so, and you've read what the ANC said, you've read what the President said, is flawed. So they go to the National Assembly and they say, don't vote for this report because it's bad. And then it turns out the ANC was completely wrong. The President was completely wrong. How can this court allow that decision to stand? That would be, in our view, anti-constitutional. It would be an outrageous violation of the Constitution for Parliament to pass a resolution on any matter in circumstances when they were misinformed. They were told the wrong facts, they were told the wrong law, and they voted. I'm not worried about the party system, we understand that. The EFF do it. My client's only got 2 members of Parliament, so hard for the leaders to...
your client is an important party.
It's important that this court recognizes so when Parliament acts, it acts rationally. And whenever it does so for good reason, not for bad reason. And when it acts for bad reason, and an important matter like this, comes around every 10 years, impeachment of the President. And if we stand back, I mean the elephant in the room, what's the elephant in the room? A couch with $500,000 they're unaccounted for. They will all just turn a face to that. That's what the elephant in the room is. And the President hasn't had his day in court. He hasn't had his inquiry. No tax. Reserve Bank say they've got no record of these money. If it happened to any of us, we wouldn't be sitting with a clean bill of health as it was today. At least we'd have had our day in court, and we might have won. We might have said, oh, well, it was advice. It was this, it was that. There's the elephant, standing there.
Thank you, Mr. Katz. You've gone considerably way beyond answering that question. But just finally, if you say ultimately all that we may need to deal with is the rule, and if there's no application for direct access, then if that's all that we left with residually, why should this court then deal with that? And why would that not be appropriately dealt with by the High Court?
No, I don't say that all you left was the rule. I say that the rule and the resolution.
You said that even if we don't, we are not with you on the resolution, we should at least then deal with the rule.
No, I think the other way around. I think what I said was this: if you're with us on the rule, then you bring both legs, the rule and the resolution. But if you're against us on the rule, then you've got to go to the resolution anyway.
Okay. I'm sorry, Mr. Katz, maybe I sort of misunderstood the importance.
I apologize if I didn't make it clear.
Mr. Katz? Mr. Katz?
Oh, sorry, Justice Mshlamfa.
Thank you.
No, I saw something.
Okay. I still want to go back to the delay point that you've touched on. And my concern is that the cases that you have referred us to, there the explanation for the delay was provided. And what we have, there is no explanation whatsoever.
Yes.
And normally we get an explanation, we then have to decide whether the delay is undue, whether we should overlook it based on the explanation. What should we do when there is no explanation whatsoever?
I've got two answers.
Okay.
The first is delay is a red herring in this case. It doesn't play a role at all, because you can always challenge the rule. You can challenge it today, and nobody can accuse me of delay. It's there, it's on the books. For the purpose of the rule. For the resolution, I accept the proposition. The second answer that I give, this is such a serious matter. And yes, I can talk about the elephant in the room, and we all know what's going on here. What do the interests of justice say? In this case, excuse the delay, deal with the resolution, and if you find that the resolution was okay, it was rationally passed, then my client has to live with it. He laid the complaint with the Speaker. The Speaker gave him a tick box. Panel gave him a tick box. He hasn't had an impeachment committee hearing. That's serious. It's a very serious constitutional matter. And for this court not to consider the substance of the challenge to the resolution because of delay, we would submit, would not be in the interest of the Constitution. It's as simple as that.
Now, coming back to the rule itself,
Yes.
assuming that the issue of direct access is not a problem, and then one is able to deal with the challenge. And if we are with you and the EFF on the challenge, the outcome that is sought is that once a report is submitted by the panel, it should not go to the National Assembly. There should be no vote on whatever. Is that what?
I do apologize. It was in my 10 minutes. We submit the following, and I haven't typed this up, and it's not going to be fair on my respondent colleagues, but this is the submission. I had said in my address that 6.1 needs to be tweaked, and this court will decide how to tweak it. Because clearly the rule is, in our view, the rule is clearly unconstitutional. The problem is, and it's a difficult problem, and I haven't got the full answer, how do you tweak 6.1 as the EFF have drafted? How would the ATM suggest that 6.1 should look? And I've got it written down, and it's a simple variation of 6.1. The rule, let's call it rule 129I, but it's really 129I in context, is unconstitutional to the extent, because that's what 172(1)A tells the court. You declare something, a piece of statute or a regulation or a rule, unconstitutional to the extent that, and then you decide what the extent is. It treats, sorry, it treats a determination of whether the President committed a serious violation of the law as a political issue question, and it shouldn't. It's a legal issue, it's a black or white issue. The panel plays no political role, none. And so the real issue is the question that the panel had to look at, the sufficiency of evidence and the Section 89 criteria, should be regarded as purely apolitical. So nothing to do with who the president is, which party he belongs to. Did he elephant in the room the dollars?
So one should look at the substance of the report, and not one should look at the substance of the report, and not a party line or how one should vote.
No, I'm not trying to. Sorry, I must.
No, I'm saying you are saying the issue of party line, how one should vote, should be excluded when it comes to.
Absolutely. When it comes to the question of accepting the validity of the report and to whether to have an impeachment inquiry, there should be no party interference in that decision. It should be, not what I say, it's what this court said in EFF 2. EFF 2 said that. It said, when it comes to whether or not there should be an impeachment inquiry, politics can play no role. I've just read it to you by parity of reasoning. That's what I've read to you. And that's why, when it goes to the National Assembly, and we know, the answer is here, the ANC tell us. The ANC tell us it went along party lines. The ANC looked at the report, didn't like the report, told their members what to do. We haven't got a problem with that, as a matter of principle, for this case.
My understanding of the EFF's case is that, in fact, the referral to the Assembly should be excluded altogether. So from the panel straight to the impeachment committee. That's what they are seeking.
If that's effective, what I'm saying as well, but that's not for the court to decide. All that the court has to decide what they've actually done. The rule that they've actually made is bad. You don't have to decide how they should fix it, whether it should go straight or whether the National Assembly. That's not for this court to decide. That would be a separation of powers potential problem. All that this court has to do is say it's bad. It doesn't have to say, well, it's bad, this is how you fix it. It's not for this court.
Thank you.
Mr. Katz, you said that the National Assembly decision would fall automatically if your attack on the rule is good. Did I understand you correctly?
This is how I understood my submission. We submit that the National Assembly resolution was bad.
I've heard your argument as to why it's bad on its own, leaving aside whether the rule is good or bad. But I understood you to say in the first instance that if the rule is bad, it automatically vitiates the National Assembly's decision.
The answer, yes. I accept, sorry, Justice Rogers.
Well, my question was going to be that would be true only if the rule were retrospectively invalidated.
And that goes to section 172(1)(b) type consideration. I accept that.
And the applicant, at least, I'm not sure if in your client's papers it argued for it differently, but the EFF asked that the declaration be suspended for 12 months. So that's paragraph 7 of its notice of motion.
Yes, Justice Rogers, the answer to them is suspension doesn't mean no retrospectivity.
Yes, but it means that the declaration is not operative at all.
But it becomes operative at the end of the suspension.
Yes, well,
and that's why
that means we can't now take any decision about the National Assembly rule on the strength of that declaration, which has no current effect.
I would submit that they're separate prayers. So that the suspension prayer and the striking down the resolution prayer are different in kind.
No, they are. I mean, they're different numbers. I don't care whether they're A's or B's or 1s or 7s. I'm only concerned just to establish that unless we refrain from suspending the declaration and make it retrospective, which would be the usual position unless we limit retrospectivity, then there is no domino effect on the National Assembly's decision.
So perhaps, yes, Justice Rogers, I have to think about it. I'll come back and reply. But I'm interested, was my submission that prayer 7 should be granted or not? I just want to remind myself.
My own notes had a question mark against prayer 7.
Yes.
Perhaps you should now say it should be struck.
There should be no prayer 7. That's the answer. Yes, and the reason is they haven't made out a case for that suspension. My learned colleagues on the right to speak in the
make
present.
out a case if the applicant asks for it.
I accept that, but that doesn't mean to say that the applicant has made out a case for it. Justice Rogers, the simple proposition is this. There's no reason on the papers why there should be a suspension. In EFF 2, there couldn't be a suspension because there was no rule to suspend. But the proposition... Yes. Well, I suppose, the question, I suppose, is always, if there's no suspension, what chaos would ensue were the declaration to come into operation immediately? And we can't think of any. But it's none in the papers. I mean, I know that a couple of weeks ago, I think Justice Rogers, you weren't in the case, but Justice Malema asked me the question that where there's no evidence in a Section 36 limitations inquiry, should the court nevertheless inquire into when it's a rationality challenge? And I answered, I think tentatively yes, and I'll wait for the judgment, but the problem, I don't know what's going to come, but the problem, the issue I suppose, is that answer in that case would probably be a similar answer here. This court can look and see would there be chaos were the rule not to be suspended. But I can't think of any. I can't see any new presidents facing an impeachment with a rule that with 129I is bad. I can't see it.
Then my other question has to do with what you read out as to the extent of the invalidity of the rule, the basis of the invalidity that you suggest we might grant. I understood the essence of it to be that it would state that it is invalid to the extent that it treats the determination of the question whether the President has committed impeachable conduct as a political question.
For purposes of determining whether there should be an impeachment committee,
Yes.
that's the essence, yes.
Now, from that, do I understand your submission to be that Rule 29I, as it currently reads, treats that as a political question? In other words, on a proper interpretation of Rule 29I, does it treat that question as a political one, or does it treat it as a question on which members of Parliament must vote according to what they think is right?
Well, we will submit those, the two propositions that you put, the two distinctions are one and the same.
Yes, that's why I put them as I did.
But
If treating it as a political question is the antithesis of considering what you believe to be right, I would have thought.
it shouldn't go to Parliament because going to Parliament, it's treated as a political question. Parliament is in the business of politics.
But it has to go to Parliament.
Yeah, well, as the rule stands.
Are you saying that Parliament should not actually be involved at all?
No, what I'm saying, that's what I think I answered Justice Mashrantla by saying that. I'm not giving an answer to the question. I'm just posing what the problem is. When the question goes to Parliament as to whether there should be an impeachment committee at all, it's a political question as to whether there should be an impeachment committee, and EFF2 said that's a bad idea.
Yes, but do you say that by declaring the rule invalid to the extent that it treats it as a political question, do you equate that with saying that Parliament, the mere fact that Parliament can consider that question makes it a political matter?
As it is at the court.
So what you are saying is that at the stage of the IP report and whether the next step of a referral to the impeachment committee should happen, Parliament must simply not be involved, because as soon as Parliament is involved, it is inherently a political matter.
That's what EFF2 says. And we support that.
Well, certain other propositions were put to Mr. Premid by my colleagues to the effect that EFF2 seemed to indicate that Parliament did control the process, and including this question. I might be wrong, but as long as I understand you, you say the first time Parliament must consider the matter is when the impeachment committee has done its work.
Effectively.
Because up to then there'll be a party's motion, a speaker checking that it's in order, an independent panel which does not consist of parliamentarians, then an impeachment committee I assume it consists of, does it consist of parliamentarians?
Only parliamentarians.
Yes, but a small body of parliamentarians, and finally it comes before Parliament to decide, do we impeach or not? Do you say then it is a political question?
Yes. Yes.
So at that stage,
yes,
it can be decided politically regardless of the merits.
And I'm thinking of a classic example. I was trying to think of examples where at the end Parliament could act rationally but reject the impeachment committee's finding that the President had acted in violation of Section 89, rationally, like I emphasize. And one can think of a case where, for example, the President's got a few months to go of his presidency. He's committed a serious violation under 89, 1, whatever the section are, in bad faith. And to impeach him at that point may not be in the interest of the stability and otherwise of the country. And there could be a whole range of, let's call it, extra 89 reasons. That's the best I can give. Because otherwise we're in dangerous territory of saying that that National Assembly at the end also must be bound by the impeachment committee, and I'm not going to make that submission. Ultimately it's for Parliament to decide.
Then, if I may say, you may wish to go back and reconsider your formulation of what you're going to ask us to do, because it seems to me not to say directly what you actually intend.
No.
What you actually intend is that the whole of Rule 129I is invalid, because that rule is only concerned with the matter going to the National Assembly. And if that inherently makes every feature of that you say the rule as a whole is bad.
As it pleases the court, yes. I did say that I had struggled tweaking it because the way it's formulated currently in 6.1 doesn't give effect to what we really submit should be the answer. I know Mr. Premier has argued for it in the way that I've argued for it.
Yes. You see, my concern was that the way you formulated it would suggest that it could still go to the National Assembly, but the National Assembly and its individual members must not treat it as a political matter.
Yeah, I accept.
Whereas you say it just shouldn't go there at all.
Absolutely. I thank you, Justice Rogers. You've clarified the submission that I wish to have made. Thank you, Chief Justice.
Mr. Katz, I have two issues, but I'd like to start with this one now because it's fresh in your mind. You're an intervening party before the court. Just as a matter of procedure, you seem to want to suggest that we should get rid of paragraph 7 of the notice of motion. Shouldn't you first get a mandate for that, in as much as you're acting for a two-person party there, not the applicant? I say it tongue-in-cheek only half, because I think it's a serious question.
It's a serious question.
Intervening party, you can do that.
Well, I'm not sure that we are an intervening party. That's my first answer. We're an applicant. We were a respondent.
Oh yeah, you're an applicant.
What happened here was we were a respondent, and if there's an interesting law which I've learned in ATM versus the Speaker of the full bench of the High Court, which is about this very resolution, but whether it should be secret ballot or not. And what happened was the ATM were the applicant, and the respondent included the EFF. And the EFF supported us. And the ANC said, no, they must come in as an applicant if they want to do so, because it's not fair to the respondents. And that's what we recognized in this case. So the ATM joined the EFF.
You also said so in the elections case, that the judgment that I wrote, remember? Oh, you wouldn't remember. But
Which
anyway.
one was that?
But this is the point. You came in as an applicant, but whose notice of motion is this? Is it your notice of motion, or is it the EFF's, or both of you?
Both.
And if it's both of you, is 50% enough to get rid of the paragraph 7? I'm asking it because I think you might take instructions or enter into negotiations with the EFF.
Let me say this. It's actually me talking. I've also got a responsibility to the court as an advocate. So even if there's what the client might want, I try never to just do the client's bidding. I try to at least make submissions that I believe in. Sometimes I succeed and sometimes one doesn't. But the proposition is, I'm not sure that paragraph 7 of the notice of motion is necessary from a legal perspective, but I'll leave that to the court.
That's the best traditions of the bar, and that's a duty of counsel to the court. You're right.
Thank you.
But here's my problem. If paragraph, I think you have disavowed paragraph 6.1. You see the difficulties there with 6.1.
In its current formulation.
In its current formulation.
I do submit that